Hi, I'm divorce attorney Kevin Kensik, and what I'd like to do today are talk about different processes of obtaining a divorce. In any type of a divorce case where you're trying to terminate your marital status or end your marriage, each case, no matter how you go about doing it, requires the filing of a petition in the county that you live in, and a case number is then issued. Then, no matter what process you use, both parties have to do financial disclosures for each other so that there's some sort of transparency in the divorce process. And then the parties can come to an agreement, and a judgment or marital settlement agreement ends up getting filed with a court. All three of these processes or filings are required no matter how you go about doing the divorce, whether using a mediator, collaborative, or any other process. What I want to do is explain those different processes. There's basically about 5 or so different ways or processes of going about getting a divorce. The first is a default. That's when one party, called a petitioner, we don't call him a plaintiff anymore, the petitioner files a petition with a court and serves the other party, and the other party refuses or fails to respond. In that case, the petitioning party can go to court, request what's called a prove-up hearing, and get a default judgment. Those don't happen often. They usually happen when there are very little or no assets or no children involved. There's also an uncontested process, and that can occur when one party files the case. The other party doesn't necessarily want to file a response, but the two can come to an agreement, again entering a stipulated agreement, judgment, or marital settlement agreement. Another type, or the more common that you may hear about sometimes, is a litigated case where each party might get an attorney or represent themselves and then want to go to court on different motions, hearings, or a trial. That's basically the traditional litigated model, but your case doesn't necessarily have to be litigated. Many people never see the inside of a courthouse. Another type of process that people talk about is a mediated process, or using a mediator. Usually people will get a mediator who acts as a neutral, and it usually is an attorney, and they will try to get the parties to come to some sort of an agreement, keeping in mind that that lawyer or mediator does not represent either party. Each party is basically on their own, and often a mediator will recommend that you go see your own attorney when they put an agreement together. There's also been a new recent type of divorce process called the collaborative divorce process, and basically in that process both parties retain their own attorneys, but they also have to have coaches, and there's a neutral financial person. I'm happy to explain all the different processes to you in detail, and based upon the facts in your situation and your case, make a recommendation for which model fits you best. I'm divorce attorney Kevin Kensik. Please give me a call, and I'm happy to answer any of your questions.